Wonderful. Thank you, Joan. It's my pleasure to give this presentation. So I'm going to talk not just about wills and trusts, but healthcare power of attorney, financial power of attorney, and I have a little bit of information on scams, how to avoid scams at the end of this presentation today. And I have to give credit to my intern. I have two wonderful interns from Michigan Tech who are helping me. And Haley helped with this presentation, and she helped with adding in the section about scams.
Excuse
So
me,
jumping right into wills
Kate,
and trusts.
speak closer to your microphone. You're very soft.
Where is my microphone? I don't even know where it is. Can you hear me
Probably
now?
at top of your screen.
Okay, can you hear me now? Better?
Yeah, I think so. How about you, Bill? Is that better?
Okay, because I can put on my headset. I wonder if that might make it easier.
I, I don't know. I can hear you fine.
Okay.
Anyone raise your hand perhaps if you're having trouble?
Definitely raise your hand if you're having trouble. I might have to reach back into my theater training and learn how to project a little bit more. But wills and trusts, we're going to start with wills and trusts. I am not going to say too much about trusts because this is something that legal aid, we don't do trusts. If somebody needs a trust, we'll refer you out to a trust attorney, somebody who can do the more in-depth. But for a lot of people, the first question they have is, do I need a will or do I need a trust? And for the most part, I would say most people don't need a trust. They only need a will. If you have a house, you have some property, you might have a retirement account, you might have bank accounts, all of that can be handled actually outside of a will. And if you have multiple businesses and you have complicated finances, then probably you should look into doing a trust. That's kind of the simple, basic way of looking at, do I need a will or a trust? Most people, a will is going to be sufficient. And in Michigan, even if you die without a will, Michigan has what's called intestate succession, which by operation of law, your property will be transferred to family members according to intestate succession, meaning your spouse gets first, your children next, your siblings after that, then your parents inherit after that, and then other relatives. And then if there's no relatives anywhere at all, then it will, a sheet, go to the state. But for most people, you just don't have to really worry about that. And if your estate is fairly simple, just having a simple will is going to be sufficient for your family. And I know for a lot of people, it's really about peace of mind. And I know a lot of people want to avoid probate. So what a will does, a will disposes of anything that's left in your estate when you die. So what's left in your estate? Generally, for most people, it's going to be their house, and pretty much that's it. There's not going to be a lot more that's going to be left, because if you have retirement accounts, you generally name a beneficiary, so that's going to pass outside of your estate. And what we recommend to people when they want to do a will and they have a property and they don't have 10 children, usually if there's 10 children, this is hard to do. But if you don't have 10 children, then a ladybird deed will take your home out of your estate so that your family will not have to open up a probate estate. Your will can dispose of pretty much anything that's left over, and there may not even be anything in the estate except maybe personal property. And a lot of times what I recommend to people when you're talking about personal property, because I've seen wars started over a pie plate, over a ring, over a small piece of personal property. So what I recommend to people is once we draft a will, and it's a simple will, I recommend that you keep with that will a piece of paper or a notebook in which you, in your own handwriting, assign pieces of personal property, especially if you have a family member who's attached to a particular piece of property. That way, at least your family knows your wishes, and that can sometimes avoid an all-out battle after you're gone. But, I often think about it, if I'm gone, I don't care. If they want to fight over it, they can fight over it. But it is helpful. It really is helpful. And we all trust, for the most part, we trust our children, we trust our family members. But, there have been occasions, and I've seen it too many times, where even very trustworthy family members turn into something else after the death of their parents. And I don't know. I don't know what motivates them to behave that way. I'd like to look into some psychological studies and find out why funerals sometimes bring out the worst in family members, but it can. And so what's important when you draft a will is to take a look at your estate and see what is going to pass into your estate. You can take a lot of things out of your estate. As I said, you can do a ladybird deed, which will take your house out of your estate. You can take a house and a second property and pull them out of your estate. And a ladybird deed, what it does is you own the house, it's your property, but it goes to a person you designate upon your death. And under Michigan law, it will pass immediately to that person upon your death. They do have to go to the Register of Deeds and present a death certificate in order to change the deed, but the property will transfer directly to them, which means it won't go into probate, which for a lot of people is a big relief because your family members don't have to go through the process of figuring out how to open up a probate estate and how to go through that process. So if your major piece of your major estate is going to be your home, we recommend ladybird deeds as a great way to handle that. I see somebody raised a hand, but I'm kind of wondering if you could put those questions in the chat and then we can take a look at them. Is that John? Okay. So, and if you do want to know more about ladybird deeds, I will talk a little bit more about ladybird deeds because a lot of people want to use a ladybird deed as a way to avoid Medicaid estate recovery. I don't want to get too far into the weeds on what Medicaid estate recovery is, but the basic premise is if you needed to go into a nursing home, long-term care nursing home, and you needed to qualify for Medicaid, and you received care that way, and then you pass away, the state of Michigan will recover your expenses from your estate. But if you do a ladybird deed, your home, your property is no longer in your estate. It will go to your family members and Medicaid can't take it. Now, there have been rumors that the state of Michigan is trying to get around this, but for now, ladybird deeds are very, very effective. If that's a concern for some people. And oftentimes it is, especially with the clients we deal with, because with a lot of our clients, that's their only wealth is their home. And so you can save your home that way, and also you can simplify things for your family by just going ahead and doing a ladybird deed. The most I have ever put on a ladybird deed is maybe 3 or 4 beneficiaries. That's the maximum, because when you start putting too many beneficiaries on a ladybird deed, you encounter tremendous difficulties. First of all is how do you dispose of the property? How is the property going to go? Are you going to sell it? Are they going to split the proceeds? What's going to happen? The more people on the deed, the more opportunity for conflicts and disagreements and problems down the road. And there are different ways of doing a ladybird deed. You want to, for the most part, people will do joint tenancy with full rights of survivorship, which a lot of my clients refer to as last man standing gets the property, meaning if you die, your share goes to the other people on the deed. It does not pass down to your heirs. What that does is that avoids your ownership of the property being diluted to we've seen situations where there is no ladybird deed, there has never been a probate estate, and property keeps passing down through the line, And sometimes by the time we look at it, there's 20 to 30 heirs because it goes to the children and then the grandchildren and the children of the grandchildren. And then it becomes a very difficult process. You can use a ladybird deed for any real estate besides your house. If you have a camp, if you have a piece of property, if it's a deed, you can do a ladybird deed. Another thing that's important to inform your family members is if there is a mortgage on the property, they will have to pay the mortgage. And Congress passed what's called the St. Germain Act, which means as long as your family members pay that mortgage, they get to keep the property, even if they themselves are not eligible under the bank rules to get a mortgage. As long as they continue to be up to date on those payments, they can keep the property. The thing is, the caveat is they've got to continue to make those payments. So, does anybody else have any questions about what a ladybird deed is? These are pretty important documents, and I think they're very valuable for people. So, and when you talk about planning for financial or medical incapacity, you're looking at, who's going to take care of the house. For a lot of families, sometimes a family member will move into the house and they'll take care of their parent or whoever's in the house. And then you've got to do a ladybird deed before you become mentally incompetent. If you don't have the mental competency, if you've got an early diagnosis of dementia, that's not going to stop you from doing a ladybird deed. Some people have what's called sundowners. They're great during the day, but they're not so great in the evening. So they can come in, they can go to an attorney's office, and they can dispose of their property when they're having a good day. So that's another important thing. I think that's a really important thing for people to remember is mental capacity sometimes can be fluid, especially as we get older. I know it does for me because I don't know how many times I walk into a room and then I can't remember why I walked in. And then I have to go all the way back to where I started and remember, and sometimes have to do that 3 or 4 times. So our cognitive abilities do slow down as we get older, and sometimes we don't know, is it dementia or is it just what a friend of mine calls old timers? So, but do know that as long as you have the mental capacity at the time that you are drafting the document, you have mental capacity. And that brings me back to drafting a will. If you're going to draft a will and you're concerned that there's going to be some kind of disputes or conflicts, or you want to exclude somebody from your will, you have to draft a will and you have to specifically exclude that family member. Because if they're an heir by law, they can go to probate, open up a probate, and make a big mess. So what you want to do is be able to go in there and exclude that person specifically in your will. And if you draft a will with an attorney and you have it notarized, then it's what's called a self-proving will, which means it becomes very, very difficult to do, to mount any kind of complaints about your will, other than, somebody might say there was undue influence. Somebody influenced you to do that. But basically, you want to cover your bases if you're concerned about, not all families are perfect, not all families are wonderful, not all family members are welcome. So you want to, if you want your wishes carried out, this is the best way to do it. And in many, many cases, if you draft a good, simple will, and if you take pretty much everything you can out of your probate estate, your personal representative simply has the job of distributing your property and making sure things go where they go and following out your wishes and not having to go through the process of opening up a probate estate. So that simplifies things for family members. And like I said, if it gets more complicated than that and you feel like you do need a trust, I would recommend you locate a good trust attorney. The State Bar of Michigan has what's called a lawyer referral service. I don't have the phone number in front of me, but it's the State Bar of Michigan lawyer referral service. And what they do is they charge you $25 for a 25-minute consultation. If you think you need a trust, I think it's an easy way to talk to a good trust attorney. and find out if that's really what you need. And they may turn around and say, no, you just need a simple will. And it's probably going to be worth the $25 to just talk to somebody who's got a lot of experience in that area and can help you out with that. So are there any other questions about will? I know, John, you had a question about ladybird deed before I move on.
There are a number of questions,
Okay.
Kate, in the chat, so I could repeat some of them to you.
Mm-hmm. Oh, good. Kirsten has the State Bar lawyer referral phone number right there in the chat.
Great. Is a quick claim deed the same as a ladybird deed?
No, no. And we generally recommend not doing quitclaim deeds. Now, if your quitclaim deed was done more than 5 years ago and you're looking to avoid Medicaid estate recovery, you're probably okay. But if you go out and do it today and you think you're going to have to go into a nursing home in the next 5 years, that's going to be a very bad idea because Medicaid will penalize you for what's called a divestment. That's why a ladybird deed is the best way to preserve, because you own the property. And even if you go into long-term care, at least still in the state of Michigan, your house remains your own property. There are some states now that are saying, oh, you have to sign something that says you intend to return to your home. But for the most part now, if you do have a ladybird deed, it's going to be protected. Your property will be protected and it will go to your family members because it's not going to be part of your estate. And Michigan can't take your property until you die. So even if you're in a nursing home, I don't know if anybody's watched the Monty Python movie where the guy says, I'm not dead yet. You're not dead yet. So they can't take your house. Yes, we do ladybird deeds.
Okay.
Unfortunately, and generally our only requirement for us to help people is we don't charge you anything. You only have to be over the age of 60 for us to help you with these documents. However, we've used up our grant. I guess we've been a little ambitious with getting people in here. But we will be we'll be doing new intakes, I believe, the 1st of April. But there are many good attorneys in the area too, local attorneys who can draft these documents for you as well. And always, I recommend having these documents drafted by an attorney because a lot of people will go online, they'll look for a simple will. Turns out the will is from the state of Illinois or California, and it's not valid in the state of Michigan. So it's really important to make sure you get a document that's going to be that's going to be recognized in the state of Michigan. And I think somebody had a question about if the will, does it have to be drafted? Ooh, it said that.
I think that might have been mine. If a will is drafted, but it's not notarized or anything, it's just exists, is it still legal? And what is the lifespan of a will and when should you update it?
First of all, if a will is drafted, I remember a very, very interesting scenario from law school where a farmer was out working and his tractor ran over him and he was dying in the field. And he wrote on the bumper of the tractor, I leave everything to my wife, and he signed his name. And
Wow.
that's a legal will. That is a legal will. Michigan recognizes it's called a holographic will. If you write it in your own handwriting and you sign it, it's recognized in the state of Michigan. Generally, what we talk about in terms of having a will drafted by an attorney and having it notarized is to avoid any kind of will contest, because then it's called a self-proving will. So the person who disputes the will is going to have a pretty hard time trying to overcome any kind of dispute they might have, because these are your wishes. You've done them in front of an attorney. You've done them, you've had it witnessed, you've had it notarized, you're of sound mind. And it's going to be very, very difficult for anybody to try to overturn what your wishes are in that will. But yes, you can write it down on a piece of paper. The important thing to remember is don't make copies of your wills. Take your original, put it in a safe place, and let your representative know where it is. Because the only time you need to update a will is if circumstances change significantly. We've had a situation where one of the beneficiaries died, so we had to update the will. There are situations where somebody's moved from a different state, so you need to get a new will done in the state of Michigan if you've moved here from another state, just to make sure it's valid within the state, and especially if you have property here. So those are just things, they're just good common sense things to think about and take care of.
Kate, there's a question. If a person who is named in the ladybird deed predeceases the originator, what happens with their portion of the property?
Then that portion of the property goes back to the originator. A lot of times, a person with a ladybird deed will sometimes say, if this person predeceases me, then I want this property to go to a secondary beneficiary. So that secondary beneficiary will take the property if the primary beneficiary dies first.
Well, or if you had 3 equal beneficiaries, one dies, then the 2 other ones would just split what remains.
Yes, the other 2. As long as you've done it as, well, it depends on how you do it. Because like I said, you can do a ladybird deed and you can assign the property as joint tenants with full rights of survivorship. You have to use that language. And what that means is if one person dies, their share goes to the other people. If you do it as just tenants in common, or your language is silent, it's going to be assumed to be tenants in common. So then your share goes to the heirs. And so as a hypothetical, take a situation where somebody's drafted a ladybird deed to her 3 adult children. One of the adult children dies. She's been in the process of going through a divorce. So now her share has gone to her soon-to-be ex-husband. And so then you're faced with, okay, what do we do about that? Do we want her share to go to her ex-husband? Is that going to create more problems? Can you go to that ex-husband and ask him to do a quitclaim deed? It just kind of creates extra issues that you have to deal with. So for most people, they feel that the joint tenancy with rights of survivorship is the best way to draft a ladybird deed and to assign, especially if you have multiple beneficiaries. But you can do a single beneficiary and you can do a secondary beneficiary. We really can't go much beyond that.
Can a ladybird deed be used for real estate other than your house?
Yes. Yes. You can do your house, you can do that piece of property down by the river, you can do that piece of property in the woods, you can do the camp, you can
But it's real
ladybird.
estate.
Yeah, as long as it's real estate, you can do a ladybird deed. As I said, the only time we have a problem, like sometimes we do have clients who have 10 adult children. We just can't. I've never done a ladybird deed with 10 adult children on it. It just seems like it just would create too many difficulties. And then we're just back to a will and having the will designate that the property be sold and proceeds distributed equally among the family members. And sometimes a person will do a ladybird deed for that purpose. They'll ladybird deed it to, say, one trusted family member with the instructions that that family member is going to sell the property and distribute the proceeds. Now, you don't know, after you die, that person might just keep all the proceeds. Legally, they can. You can't force them to follow your wishes, but if it's somebody you trust and you want to do it that way, that is an option. Some people have done that.
And do ladybird deeds only apply, well, we're talking about real estate, would it apply to personal property?
No, no. No, because it's a deed and it has to be real property. Personal property, if you're talking about a vehicle, if it's one vehicle, by operation of law, that one vehicle, a family member just needs to go to the Secretary of State and have that title transferred. They don't have to open a probate for that. Now, if you have a collection of antique cars, well, you want to do a will. Or if things are really complicated with that collection of antique cars, you might want to do a trust. Because that becomes a whole different situation. I did know somebody who had a collection of antique cars. He was actually he was actually a duke in England. So, and I have somebody, Joan was asking, if done over 5 years old with a quit claim, will it be okay? Not worth paying again to put it in a ladybird deed, yes. If you've already done a quit claim deed 5 years ago, more than 5 years ago, it's going to be more complicated to do a ladybird deed because you're going to need everybody to come in and sign off and assign the property back to you and then redraft a ladybird deed. And in many cases, as long as nobody's making things difficult for you, you might as well just leave it.
I
Do you have
think-
any other questions
Hmm.
about wills?
Can you include out of state and out of country property in your Michigan will?
In a Michigan will, you can, but you can't do a Michigan ladybird deed. You'd have to go to the state or the country where the property is and find out what their rules are and how you can dispose of that property in another state. And we do encounter that. There are people who've inherited properties in other states, but they've got to go to that. You can dispose of it in your will, and you can let people know what your wishes are. Or if you want to do something similar to a ladybird deed, you've got to go and find out what that state's laws are with regard to that.
So rental property individually owned is okay for a ladybird deed.
Rental property?
Yeah. It's another
If the
question.
rental property is individually owned, yes, you can do a ladybird deed.
Okay. If we have elderly parents who are unwilling to create a will, is there anything we can do to prepare in advance on our end?
Oh, so they don't want to do a will.
To avoid.
Yeah, basically, look into what intestate succession says. Is this in the state where they are living? So if they're living in the state of Michigan, look at the state of Michigan intestate succession. And generally, it goes first to the spouse, then to the children, and then it starts to be passed down from there. It depends on how complicated their estate is going to be. If there's property, you will have to prepare probably to open up a probate process, a probate estate. There's two different ways to open a probate estate. Again, this is something we don't do a lot of. But there's a simple estate. If the property's under a certain dollar value, you can open a simple estate, which is easier to do. If the property's worth more than a certain dollar amount, you're gonna have to go with the full-on probate. And that's a much more complicated process, and it can take up to a couple of years to get through it.
Okay.
Thank you, Kim.
Wait, wait, one more question just came up and then you can go. I mean, I don't want to hold up your presentation. Can the beneficiary of a ladybird deed be a nonprofit?
Yes. Yes.
Okay.
Yeah. And the only thing to remember with that, if it's a nonprofit, most of the time, most people who do a ladybird deed are transferring their property to a family member. So there will be no uncapping of taxes. So we usually attach an affidavit for the tax assessor's office that says, this is a deed and it's exempt from uncapping of taxes. If you are going to leave it to a nonprofit, and they know this anyway, but your taxes are going to uncap. because it will not be exempt.
Okay, we better get you talking. We
Okay.
can do more questions after that.
So, yes, and and you guys know where to find me too if you have questions about these things later on. But these are often, oh, how often should we update our wills? And if they're self-proving wills, you really, again, you don't really need to update your will if you're still living in the same state and if things haven't really changed. You might want to pull it out, dust it off, take a look at it, make sure it is truly your wishes. If you fall out with a family member and decide you want to disinherit somebody, well, then yes, you do need to update your will. And these are all things that we can help with, but like I said, is where we've pretty much used up our grant money for this period of time. So, but find a good attorney because it's always good to have something that's a self-proving will, just in case. It's hard enough when you die. Most of us leave behind people who love us, and we don't want things to be more complicated or more difficult for them in the process. So if quitclaim deed of 3.5 years changed to a ladybird deed, if you're looking at somebody who's, we're kind of rolling the dice, right? Those of us who are over the age of 60, it's like, am I going to be good for another 5 years? Am I going to be good for another? My father kept telling me when he turned 60, he says, you never know, I could die any day. Now he's going to be turning 97 this year. So he's still hanging around. He's still going strong. But you are rolling the dice. And so it's up to you to make that decision, but you want to really think about it. If you did do a quitclaim deed, you certainly can change it to a ladybird deed. You just need the consent of all the people who are on the quitclaim deed. Everybody has to change it. Because once you did a quitclaim deed, everybody now owns that property. Is that good for everybody? Can we move on? Shall we move on? Yeah?
Yeah, I
Okay.
think we should.
So let's prepare for mental or financial incapacity. I'm hoping that's not going to happen to me. I'm hoping I'm going to take after my great aunt and still be sharp as a tack by the time I'm 106. But you never know. You never know what's going to happen. There are many ways to plan for financial and medical incapacity. The first one is doing a financial power of attorney. And fortunately, the state of Michigan has passed a new law called the Uniform Power of Attorney Act, which means that a properly drafted power of attorney has to be recognized by all institutions. We used to have problems where we would draft up powers of attorney. Somebody would go to the bank and the bank would not accept it. They would say, no, you have to do our power of attorney. So then these family members had to go and get 5 or 10 different powers of attorney, depending on who they were trying to deal with. So now with the passage of the new law, if you have a properly drafted legal financial power of attorney, it will be accepted wherever you take it. You only need the one, which is, again, is why we recommend you have an attorney draft one of these up for you. There's 2 kinds of financial powers of attorney. The first one is called a springing financial power of attorney. With a springing financial power of attorney, your designated person only has authority if 2 doctors sign off and say that you are mentally incapacitated. There can be a problem with doing this one because it's very difficult sometimes when you regain capacity to come back and say, no, I have capacity, I want to take over my finances. There was a situation years ago where a person gave springing power of attorney to his brother. He had a bladder infection, which, as you know, acts like dementia for some people. The brother moved him into a nursing home, sold all his property, And he had the worst time trying to, and he couldn't recover a lot of what had been done. He couldn't undo it. So there are some dangers and difficulties with doing a springing power of attorney. The main one is that it's difficult to go back and say, okay, now I have capacity. The other kind of a power of attorney is called immediate power of attorney. That means your designated power of attorney has the authority right now to write checks, to handle your financial affairs, to make decisions. And in that power of attorney, you can designate what kind of powers they have. Can they sell real estate? Can they not sell real estate? Can they pay your bills? For many people, the concern is, I just want someone who can just take over my bank account and pay my bills. And it's very helpful for people, say if you travel and you have a trusted adult child who comes and takes a look at the house and takes care of your house and pays your bills for you and does all of that. These are very, very valuable documents to have. So with your financial power, and they're easy to draft, they're not difficult, but you do want to make sure they're drafted by an attorney. Again, you can go online and find them, but again, you want to look and make sure they are valid in the state of Michigan. You want to make sure you didn't download something that, is from the state of Illinois. And there's a lot of scams out there, and there are a lot of websites that are going to charge you a lot of money. And so generally it's better to consult with an attorney. It's not a difficult process and it's not horribly expensive. I really don't know. I don't know if Kirsten knows what a private attorney charges to draft a power of attorney, but I know it's not expensive.
It's going to
So,
vary.
yeah,
Cost would vary. It shouldn't take a lot of time. I would say maybe in the $250 range.
that's what I was thinking, $200 to $300. Yeah, for a private attorney to draft up a financial power of attorney. And again, we do them, and our only requirement is that you be over the age of 60. But again, we're looking at as long as our grant money is available to us. So that's where we're limited. We can only take in people as long as we have the grant money available. If a financial power of attorney was done previous to this year, will it be honored under the new law? Yes, I do believe so, because under the new law, all it has to do is it has to follow what the requirements are listed in the new statute. So as long as the power of attorney was drafted that way, it will be honored under the new law. I mean, if somebody drafted up one on their own and it doesn't comport, it doesn't meet the standards of that law, then it's not going to be honored. Does that answer your question, Jan?
If I may, the new statutory power of attorney, partly why it was designed is so that more banks, insurance companies, the third parties that are going to have to review the power of attorney to see if they'll accept it, that it's more uniform. And so that should be more easier for, others to accept it and to allow the agent to act under the power of attorney. Another attorney in our program had a situation where a banker drafted a power of attorney for his mother, and it didn't give authority to do things that the son thought he had authority to do and needed to be doing. And so, again, always good to check with an attorney to help you with your powers of attorney rather than bankers or insurance agents or realtors or that sort of thing.
Right. And you can designate, we always recommend you designate an alternate, just in case the person you designate isn't available or not willing at that time. You just never know. Life can happen along the way. So always good to designate a primary and then a secondary, a backup power of attorney. And always, of course, as you know, it goes without saying, find somebody that you trust to handle your finances. And another way to do it, because a lot of our clients will actually put family members on their bank accounts. We don't recommend that because once you put somebody on your bank account, they own that bank account. They can take everything out if they want to. Most people are not going to do that, but they can legally, and you can't get that money back. So it's good to designate a power of attorney. And the other thing to do also is when you die, your power of attorney dies with you. So another way that you can deal with your accounts so that somebody doesn't have to go into probate is to do what's called a pay on death account. So you designate your bank accounts, you designate a beneficiary. So upon your death, that account goes to your beneficiary. So with my checking and savings accounts, they go to my daughter, which means that upon my death, she can pay up my last bills, she can take care of finances, and she doesn't even have to go near probate because she's now been designated as a beneficiary. When you're looking at your retirement accounts, hopefully you've got your beneficiaries designated on your retirement accounts. How do I sign checks, etc.? If I am the power of attorney, do I always have to show legal papers, or how institute that I'm power of attorney? Generally, what happens when you sign a check as power of attorney, you sign it your name as power of attorney. And your document should be with the bank that you're writing that check on. Any more questions about finances, financial powers of attorney? Where does my money go after I die? So now we're going to look at, okay, you're in the hospital, you're unconscious, and under the new HIPAA laws, nobody has any rights to your medical file, not even your spouse. What do you do? Well, Michigan did pass a new law. Again, this is another new law that was passed last year. I think it took effect in July, which allows a family member to make decisions for you if you are incapacitated and in the hospital, which is a wonderful thing. Unless that family member is somebody that you would not want within 1,000 miles of you while you're unconscious. Because the law does not designate who that family member has to be. It just has to be a family member. So most times it's going to be your spouse. It's going to be somebody you trust. But drafting up a medical power of attorney is a good way to sit down and talk to your family members. My family, oh my God, my daughter is such a drama queen because having the conversation with her was like, oh my God, Mom, I just can't talk about, oh no, Mom, I don't want to talk about this. Oh my God. And then she started crying. I said, but I'm not dead yet. I'm just telling you what I want to have done. If you're in the hospital and you cannot speak for yourself, do you want the hospital to give you everything? Do you want them to throw all the tubes, all the invasive procedures at you to keep you alive? Some people do. That's a choice. Do you want them to do it only if the doctor says, you know what, this person's in a coma right now, but we think they're going to recover, they're going to regain function, they're going to be able to go home, then maybe yes, you want to do it under those circumstances. And then the third decision, the third choice is, you know what, I just want to give my power of attorney person broad discretion to make that decision. If I'm unconscious and I can't make that decision myself, I will sit down and I will talk to them, and it'll be between me and that other person about whether they pull the plug or they don't pull the plug. And you want to designate somebody. I designated my youngest son because I know he's going to be able to pull the plug. Not because he doesn't love me, but because he's a practical person and he'll be able to do it. My dramatic daughter, who loves me dearly, just isn't going to be able to do it. And I don't want to put her through it. So you think about those things and you sit down, and it gives you, it really, in many ways, it's kind of freeing. You have the opportunity to sit down with your family and say, look, this is what I want. And if you want to go more into detail, we can draft up a healthcare power of attorney, and then you take it to your doctor, you have it entered into your medical record, and there's no questions, there's no issues. If you end up going into the hospital, you're unconscious, it's in your record. and they know who to call, and that person knows what to do, and they know what your wishes are. And then hospice puts out a thing that's called 5 Wishes. I think a lot of people know about this, and you can download this, and it's free. So if you ever come across anything that you have to pay for it, don't do it. You want to make sure you go with what hospice puts out called 5 Wishes. That's a little more detailed, and I actually did it because there's certain music. If I'm unconscious, I want to hear certain music. I hate country music. So I want to have some control over what kind of music is being played while I'm unconscious. And it just kind of makes me feel happy to think that I can actually do that. And, I can actually make those kinds of decisions. So getting a healthcare power of attorney, getting a financial power of attorney, a ladybird deed, and a simple will is an estate planning packet that for many people just gives them tremendous peace of mind, and it sure does wonders for their family because family members don't have to guess. Many years ago, 10 or 15 years ago, my niece, who was almost 25, was in a car accident and a metal rod went through her head and she was in a coma in the hospital. And the back of her brain started swelling. And eventually the doctors said, look, she's young. We keep her on life support. Her body will recover, but her brain never will. And so the whole family is left with, oh my God, we don't know what she would want. We don't know what she would have wanted. So as soon as my son turned 18, I made all my kids draft up medical power of attorney because I want to know what they want. I don't want to have to make that decision in the dark. It was hard on our family, and it is hard. Hopefully, many people won't have to make that kind of a decision, but it's a hard one. It's a hard one. And so, because as soon as they turn 18, which kind of blew my mind, because one day I could look at all my son's medical records. The day after his birthday, I had no access to anything at all. So, but I am his medical power of attorney. So if anything happens, but again, that's only if he's in the state of Michigan. Like he was in the Army for a while, he was stationed in Hawaii. That power of attorney was not effective in the state of Hawaii. It was only effective in the state of Michigan. He would have had to do another one, in another state at that time. So if a child has joint ownership to your bank account, will that be okay? Generally, we say no. We don't recommend doing that. Do a POD account where your child gets ownership after you die. You want to own that checking account. As long as you're mentally competent, you want to take care of your own finances. And then death, check with funeral home and prepay for what you want. Generally, that's a good idea. Check with the funeral home. And it's funny, it's one thing I haven't done. It's a little too real for me. I haven't quite done it. I'm not quite there yet. But doing a prepaid funeral contract. And again, under Medicaid laws, it's over $11,000 that you can do for an irrevocable funeral contract, and it will not be a divestment. Medicaid won't penalize you for doing something like that. That's an allowable expense. My theater voice. I'm sorry. So, does anyone have any further questions about medical power of attorney, financial power of attorney, planning for your incapacity? Yes, Kim.
Okay, so I was a little bit unclear. Um, if I am on my parents' bank account just for monitoring fraud, because fraud is so terrible anymore with financial institutions, does the financial power of attorney supersede me being on their bank account just to monitor for fraud activity?
Are you talking about if they give financial power of attorney to someone else?
Well, I'm not clear. Like, should we get a financial power of attorney? Is that better than just having the agreement with the banks?
generally what we recommend is getting the power of attorney, because that gives you the power to act as their agent, but they still
Okay.
own their bank account. If you're
Okay.
worried about fraud and scams, we're going to get into scams in a little bit, and maybe we can put that on the list for something that we could talk about later on down the road too, more in depth, because there are a lot of scams and there are a lot of
Mhm.
ways to keep yourself safe and to help your parents be safe. So,
Yes,
or
because
family members.
it's been very helpful because I've had to every now and then cancel a card because of a lost purse or something to that sort,
Yes,
where, I can prevent it, it cut it off at the pass before some fraudster person taps into the bank account.
yeah, yeah. Yeah, and that's an important thing to do. When you talk about a care contract, I'm not sure what you mean. Medicaid, we've had difficulties with Medicaid. They don't like care contracts. They don't like family members. And then the rules keep changing month by month. The rules keep changing under Medicaid. So a recommendation would be to check with the Michigan Medicaid Medicare Assistance Program called MAP, and get some advice from them if you're talking about care contracts where you're taking care of a family member in the home. Because another option under Medicaid is what's called the Medicaid waiver program, which too many people don't know about. But the waiver program is where if you're eligible for long-term care, but you want to stay in your home and you have the ability to stay in your home, you can, and you can receive services. But again, Medicaid is picky about the way you get those services. And let's see. Your healthcare power of attorney done out of state, very detailed, fully accepted in Michigan. And now she lives in Michigan. If you get a healthcare power of attorney, you want to get it in the state in which you live. Because as I said earlier, my son, even though I'm his power of attorney in the state of Michigan, when he was in Hawaii, I was not his power of attorney. And he did have a healthcare crisis when he was in Hawaii. So it was a tough situation that we had to deal with. Get your power of attorney done in the state where you live. Pay on death account is done at the bank. Go to the bank, tell them you want a POD. And then all you do is you designate, and you can designate a beneficiary and an alternate beneficiary. And then we want to talk a little bit about unmarried partners. Unmarried partners have no rights. No rights. So if you want an unmarried partner to make your decisions for you, your medical decisions for you, do a medical power of attorney. That person can be your medical power of attorney. A good friend can be your medical power of attorney. Um, Sometimes it's not always family members who you want making those decisions, and you have a right to choose the person you want to make those decisions. And because of Michigan's law, it's family members who can make those decisions. So if you want an unmarried partner or a close friend to make those decisions, have an attorney draft up a medical power of attorney for you. And the same thing with financial power of attorney, the same thing with a will. You can leave everything, you can leave your property to whoever you want to leave it to. Sometimes we have to talk to family members and say, look, this person has a right to leave there as long as they're competent and they know what they're doing. They can leave their property to whomever they choose. It's yours. You have a right. So some people feel like they have to leave things only to their family members, and it might not be the case. That might not be what you want. So just be aware, know what you want, and know that you have a legal right to have those wishes carried out. You've just got to have the right paperwork in place. I'm private paying for someone to help with Parkinson's Lewy body. Hurt me if I apply for Medicaid. Oh, private paying. If you're applying for Medicaid and you're eligible, I mean, that's That's a whole different, that's gonna get all into the weeds with what Medicaid, and I think we're talking about a waiver program, and it's gonna be about eligibility. So there's a lot of really good estate planning attorneys who deal with these kinds of issues and Medicaid issues. I would recommend you calling the State Bar of Michigan and doing it's not a free consultation, $25 consultation with an attorney. Um, or you can get in touch with the Medicaid and Medicare Assistance Program. But I think probably in that particular case, you might want to talk to a private attorney who does that kind of estate planning. Okay? Thank you, Jane. And then let's move on to scams. How do you avoid scams and fraudsters? Oh my gosh. When you go online, wills and POAs that are online may not be valid in the state where you live. Sometimes they'll charge you money for something that's not even valid. So always good to talk to an attorney or be careful about where you get your information, because not everything on the internet is true and it's not valid, and there are more and more scams popping up every day, and scams that even target attorneys and are successful in targeting attorneys. Remember that most people don't need a trust. Somebody tells you you need a trust, you want to talk to somebody and find out if that's really true. It is possible anybody can fall victim to a scam, but they do target seniors. And especially, I notice up here in the UP, we have not had good internet access. There are a lot of people who've never had internet access who suddenly do, and then they get a cell phone, and then they get this lovely text message saying, "Hi, beautiful. I hope you have a wonderful day." That's how a romance scam starts. And sometimes they answer that text message. And the person can be they claim to be from Ukraine, because a lot of people in this area are very sympathetic to Ukrainians. And one of the most difficult things that elder law attorneys deals with is trying to even convince somebody that they are the victim of a romance scam. They are mostly convinced that this is true, this is happening, this person is going to be moving out here, they're going to come live with me, they're going to be my bride or my husband, and life is going to be wonderful. And they go on for months and months and months. A recent one, a Ukrainian one, is where the person pays $2 per text message to their Ukrainian bride-to-be. They've never spoken to this person. They've never seen this person. They've never heard this person's voice. All their entire communication is by text message, and this person is convinced that this is going to happen. This bride is going to be moving out here. And a lot of our people don't have a lot of money. This person's going into debt, and he owns property. And a lot of people are being targeted for their property too, as well as, and gift cards. And $2 a text message. That doesn't seem like a lot until this person's $30,000 in debt because he spends all night texting with this person. They're very profitable for the scammer, and they're so incredible. And it's so hard for family members watching another family member who's absolutely convinced that this romance is real. This romance is really going on. So a lot of times the best thing to do is be proactive. If you see a message pop up on your cell phone, or if you have a family member, a senior who just has a brand new cell phone, and they're okay with it, check their text messages. Find out if there's something going on, because I've even had them pop up on my phone, and it's always from a number I don't recognize. So why would I answer it? But a lot of people do, because they're isolated, they're not aware of what's going on, they're not connected, they haven't been connected to the internet for a long time, and it's so easy. They're such easy targets, and it's heartbreaking to see them lose so much money and resources. And But I know another person, she's a relative of another attorney, and she says it might be a scam, but the person makes me feel good, so I'm going to keep sending him gift cards. And so it's really, really difficult to break this once it's been established. These romance scams they're the bane of our existence. Don't like them. So it's good to have a heads up, pay attention, see what's going on. And there are lots of other scams. I think we have another slide up here if we could, because I think Haley gave us, yeah. So here's an example of a scam. Hello, I always enjoy, la la la. So it seems like, somebody's just trying to reach out. Seems like a nice person. And I know my father's generation grew up trusting the media because he had Walter Cronkite. And I think that's why a lot of our seniors, especially, our generation and the generation before us, tend to be more trusting of these kinds of messages. And then, so just take a moment to think about it. If it's somebody you don't know, it's probably a scam.
It's still going on?
And then do we have another slide?
I don't think it should be running out of juice now.
It's sad.
Okay. So again, here you recognize online scams. Verify the legitimacy of the contact. Double check. Because USPS is never going to contact you at this particular email address. There's a new one that came out. I almost clicked on it. Amazon said, oh, your recent purchase, your account is going to be billed $1,400. I saw the $1,400 and I started to click. And then I realized, wait a minute, I'm going to go to my Amazon account and find out if this is really happening. So just give yourself a second. And of course, everybody knows the grandparent scam. Your grandson's in jail, you got to send money right away. And then with AI and voice recognition, these guys are becoming very clever about how to get people roped into these scams. We're coming up on tax season. You're going to be getting them from the IRS or claiming to be from the IRS. And again, places like the IRS and Social Security, they're not going to contact you by text message. They're not going to contact you by email. They're going to send you a letter. And you can always go into your Social Security account and double check what's going on with your Social Security account. So just be aware. And if you don't know the area code, if you don't know the email, and some emails are sneaky, there's one letter off, or, it's not spelled quite correctly. And in some cases, the font is a little bit different. So you have to be very, very careful when you see these things pop up. But anything that pops up that says, oh my God, you better act right away, probably is a good idea to just stop, don't click on it. Go directly to the source. If it's from your bank, go to your bank. Go to the IRS. Go to your Amazon account. Oh, there are so many Amazon scams. It's ridiculous. But go to your account. Go directly to the source. Don't go to the text message or the email. That's the best way to protect yourself from the beginning. And it's hard. We've got people who they're just not savvy, and they grew up in a generation when you could trust. And we're not there anymore. That's just not the situation. So we do have to be careful. With that, I will end. If anybody has any other questions, thank you for having me. I've enjoyed talking to you. Sorry I didn't keep up my theater voice the whole time, but I'm working on it.
Wow, so much information. I hope you all were taking some notes. But thanks so much for the references. And do recall that this has been recorded. And so all of the information that was shared will be in the recording. You can go to the qniuu.org website, and it's under the drop-down worship, because forums are under that. You'll find this recording that will have this information. Dave, for the recording, will it also